Hi, we'll be presenting on our Criminal Law 2 assignment and these will be our members. I am Cindy.
Hi Wendy. Hello.
Carmen.
I'm John. Hey, are you aware of the law of registration and notification on the sex offenders? Wait, the people behind me are arguing about it.
Now, I believe that the registration and notification requirements under the Act in the UK are justifiable.
Huh? No, I disagree.
What are you guys both arguing about? We don't even have that in Malaysia. Why don't we have that?
Because we have a child registry, but even then I think it's not effective.
Why don't you guys settle it over there?
In the UK, the notification requirement on sex offenders were introduced in the Sex Offender Act 1997. The 1997 Act established that offenders convicted of certain sexual offences would have to notify certain personal details to the police and any subsequent changes to these details. In 2000, several changes were made through the Criminal Justice and the Court Service Act. The maximum penalty for a breach of the notification requirement was increased to 5 years imprisonment, and sex offenders had to make their initial notification within 3 days of their conviction. After completing a major review of sex offence registration, the Parliament replaced the 1997 Act with the Sexual Offences Act 2003, which produced more stringent notification requirements. Part 2 of the 2003 Act now replaced Part 1 of the 1997 Act. Anyone convicted of any of the sexual offences listed in Schedule 3 of the 2003 Act is automatically subject to the notification requirement in the 2003 Act, meaning that they must notify their local police of their name, address, certain other personal details. Having said that, the view taken by Lord Phillips in this case must be noted. In this case, the two sex offenders who were subject to the lifetime registration requirements appealed to the Supreme Court, arguing that the 2003 Act violated their right to privacy under the Article 8 of the ECHR. The court found an interference with privacy rights because the registration information had the potential to reach third parties. It was also held that if those who were subject to a lifetime notification requirement could show that they no longer pose any significant risk of committing further sex offences, then there was no point in subjecting them to the interference with their Article 8 rights that notification would impose. In comparison, apart from the Child Amendment Act 2016, which provides for the establishment of the child registry, there exists no specific law in Malaysia to govern the registration and the notification of the sex offenders post-release. Having said that, it must be understood that there nevertheless exist different levels to such law on the registration and notification when applied in operation of the sex offender registry as available in different jurisdictions. For example, the Megan's Law in the US and the Sarah Law in the UK, which has often contended as an improvement of that of Megan Law. The most obvious and fundamental difference between the two is the way in which the information is accessed. To illustrate, if interested, parents within the UK have to go to the police and inquire about someone who is close to their child. Whereas in the US state, a parent or even any citizen is able to access all the information about registered sex offenders, such as their name, address, and even photos.
We will now move on to evaluate the laws and determine the extent to which the law is justifiable in the context of English law. The Sex Offenders Register is commonly referred to as the Register. It is a record of those required to register with the police under the Sexual Offences Act 2003, and it is not a physical document that the public can access. How then is registration and notification under the Sexual Offences Act 2003 justifiable? Firstly, the consequentialist approach. Registration and notification under the Act is justified because sex offenders represent a greater risk to the public than other categories of offenders. This will protect the public, especially the children, from sex offenders. It must be noted that they are not punitive in nature. Secondly, it is justifiable on grounds of deterrence. The registration and notification requirements deter sex offenders from committing new offences. Registration places a defendant on notice that when subsequent sexual offences are committed in the area that he lives, he may be subject to investigation. With deterrence comes reduced rates of recidivism. Thirdly, registration and notification enhances efficiency in tracking down sex offenders. A national register would allow the police to track down re-offenders faster with the information required by Section 83 of the Act as an initial notification. Changes to notification as required in Section 84 further enhances the efficiency of tracking down sex offenders. The statutory requirement of Section 87, subsection 4, subsection B will make it easier to identify offenders and harder for them to change their physical appearance and emerge undetected in another country. Section 86, subsection 1 requires relevant offenders to give notification before they leave and if they subsequently return to the UK. On being notified of the travel, the police may quickly make an assessment if the risk of sexual harm may be posed. Fourthly, the registration and notification requirements are justifiable due to the availability of review of indefinite notification requirements. The Act was amended by its Remedial Order 2012. Offenders who have been subject to notification requirements for a period of 15 years are eligible to make an application to the police for review and can make an application to the Magistrates Court following an adverse decision by the police. Fifthly, there is a more stringent approach with regards to a conditional discharge. Section 134 of the Act now this applies, Section 14 of the Powers of Criminal Court Sentencing Act 2000. This is further exemplified in the case of R.N. Longworth, whereby it was held that a conditional discharge will now be considered a conviction for the purposes of notification requirements. We will now look into the current notification laws in the UK and how they are justifiable. It must be noted that we are looking into notification in the context of dissemination of information of sex offenders to the public. The current approach taken by the United Kingdom is justifiable because it is not a system of absolute public notification as adopted in the United States, which is the Megan's Law. When citizens are given access to public information, there is always the possibility of vigilantism, sometimes against entirely innocent individuals, and this was what reportedly happened to Dr. Yvette Chloe. Also, the responsibility of monitoring dangerous situations should be left to officials who are trained to deal with offenders rather than defenseless citizens. A passive community notification, whereby the police would only release such information if there is a genuine need for it, is seen as an attempt by the UK in reducing social stigma attached to the offender. The current notification law in the UK is justifiable in the sense that they value private reputational interests more than the United States. For instance, when a media organization reports a criminal suspect's identity faces, the media can be held in contempt of court. Under Section 11 of the Contempt of Court Act 1981, the courts may order that the defendant's identity remain anonymous. The UK believes in naming and shaming only non-compliant sex offenders by placing them on the most wanted website. As a contrast, in Smith and Doe, the United States Supreme Court recognized that humiliation is a consequence of being on the sex offender registry.
On the flip side, Article 14 of the European Convention of Human Rights provides that if the communities have the right to know the presence of convicted sex offenders, then they have a similar right with respect to other risk violent criminals. However, notification requirements are not imposed upon many other crimes of violence, such as murder, robbery, or burglary. It seems unfair and unjustifiable to impose it among sex offenders. Therefore, the criminal treatment of sex offenders and safety of the majority of the public have to be balanced. There should have some degree of right of information for the public, and at the same time, to make sure that their treatment and punishment are not exceptional to other offence punishment. If the sex offenders' information were available to public, then there might be concerns of vigilantism, including acts of vandalism, harassment, and violence. In the case of R.C., she had sexually abused children, and he was a pedophile who posed a considerable risk to any child. The relevant police and authority applied for permission to discuss the judge funding to seize present landlord, the housing association, and the future landlords. However, the court ordered the disclosure only for current landlords, but refused for future landlords. And one of the factors that the court had considered is the direct impact of vigilantism. And the registration and notification process amount to a significant burden beyond that contemplated by Article 8 of the European Convention of Human Rights. In this case, the court noted that the concept of private right is a broad term not susceptible to exhaustive definition. And in this case, the court held that private right encompasses both the physical and psychological integrity of an individual. And in this case, the court ruled that private right includes social identity. It can therefore embrace multiple aspects of a person's physical and social identity. Given this guidance of interpretation of Article 8, the information which is linked to an individual's personal and private affairs falls within the definition of private right that contained in Article 8. And based on Article 8, Sub 2, privacy of a person can only be interfered with if it is necessary and proportionate to do so. Given that the regulations are capable of infringing individuals' rights under Article 8, it must be assessed whether they are necessary and proportionate measures. Sex offenders must notify the details to the police at least annually whenever they stay qualifying period, double work for more than 3 days and so on. Therefore, it must be accepted that notification requirements do act as an interference with the rights of the individual. The question is whether it is a proportionate measure. In this case, the court held that when an offender poses a low risk of danger, the requirements are an administrative nuisance. However, if a person does not pose any risk of harm, then even an administrative nuisance is a disproportionate arbitrary interference. And in this case, the court noted that the notification requirements amount to an interference with an offender's right under Article 8 of ECHR, and they unquestionably amount to an inconvenience. Further, one element of proportionality is that an individual's right should not be interfered with beyond that which is necessary to pursue the legitimate aim. Also, when an individual can show that he no longer poses a danger, then the interference should end. And further, the decision of Court of Appeal in this case was that the framework in the UK for potential disclosure of all convictions was deemed incompatible with Article 8 of ECHR. And in the case of Linder in Sweden, the court has also ruled that storage of data relating to a person's private life does in fact amount to an interference of private life as defined by Article 8. Also, Sexual Offences Act 2003 Regulations 2012 extended the existing provision of Sexual Offences Act 2003. And one of the requirements for the sex offenders is to notify the police of all bank accounts and credit card details. And considering the level of personal information which bank account records contain, and the lack of any safeguard to protect this information from misuse or fraud, it necessarily follows that this information falls within the definition of private life as protected by Article 8, and it cannot be said that the extended registration requirements are a proportionate measure.
Malaysian context. The public has displayed heightened concern following the return of Salva Kumar Subaya to Malaysia after serving a 24-year jail term in Canada, over the considerable prospect of a notorious serial rapist being set loose in the absence of specific law targeted to regulate the movements of convicted sex criminals, as he was appraised by the Canadian prison authorities to be high-risk offender prone to recidivate. Although the existing Registration of Criminals and Undesirable Persons Act 1969 was enacted to consolidate and amend the law providing for the registration of certain criminals by keeping record of their finger impressions, photographs, and other registrable particulars, such data collected serves no meaningful purpose in this respect, apart from as evidence admissible in court if and when called for, as it comprises nothing more than basic information in authentication of the convict's identity. Fundamentally, as it is not specifically catered to combating and handling sexual crimes, it is therefore only capable of offering fragmentary assistance at most, since such database is neither meant for public consumption, making aware of all potential threats, nor can it be put into effective use by the authorities to keep sex offenders in check. As such, the creation of an official sex offender registry alongside comprehensive laws on registration and notification of sex offenders have thus been widely urged for in times of need to counter such lacuna in our current system, particularly in protection of children and other vulnerable persons. Referencing past widely publicized cases, it can be observed that sexual offences are on the rise in Malaysia, with most involving victims under 16 years old. From the case of Nurin Gazimin to the recent case of Nur Fitri Azmir Nuruddin, as well as Richard Huckle, these exemplify nothing but increasingly disturbing growth in both size and scale of sexual violence back at home at an exponential rate. With the discussion on establishing a general sex offender registry still at its preliminary stage, the government's latest effort in implementing the Child Registry, a database listing the details of convicts who have committed crimes against children under the Child Act Amendment 2016, is not only commendable but highly justified. Essentially, its effect is twofold. Firstly, by putting in such mechanism to allow law enforcement agencies to 1. Monitor and place appropriate restrictions on the movements and activities of offenders, depending on their type of offence, sentence length and risk of recurrence, and 2. Impose a more serious penalty on those convicted. It functions to help in deterring offenders present or future. Secondly, by permitting for screenings to be conducted when necessary on individuals applying to work with children or in environments that are frequented by children. It serves as an added safety measure to lessen the likelihood of sexual violence victimization or perpetration by buffering against risk. Having said that, detractors have often put forward the argument that such practice would risk violating the rights of those on the list. It is submitted, however, that with adequate safeguard attached against the abuse of information, for instance Section 15 of the Child Act, which states that anyone who shares an uncensored story would face up to a maximum of 10,000 ringgit fine and 5 years imprisonment. Any such speculation over their rights being so violated would be rendered redundant. Whilst a person's right to privacy, as recognized under Article 5 of the Federal Constitution, according to the Federal Court case of Siva Rasas Rasia against Badan Peguam, Malaysia, it's important and should be respected. It should be reminded as well that the rights of women and girls in Malaysia for a safe environment are equally deserving in reference to Article 8 of the Constitution, which stipulates that all persons are entitled to the equal protection of the law. Besides, with today's easy but unfiltered access to any desired information through the use of internet, it's arguably more pragmatic for there to be an official registry with appropriate access and use constraints put in place instead, by retaining control over the relevant information. This can help strike a balance between competing interests whilst providing practical solution in aid of reducing sexual offences that had pervaded Malaysia.
Proponents of the register are of opinion that a registry fills in the gaps of the law in its practical implementation post-sentencing, as it helps track and monitor convicts released. Opponents of the register argue on the issue of the insufficiency in the law governing the offences itself, as well as the sociological implications that renders a sex offenders register ineffective. Malaysia may have a general register under the 1969 Act, but this existing database for convicted offenders only covers offences listed in the first and second schedules of the 1969 law. These offences include rape, buggery with an animal, anal intercourse against nature, and thus very few registrants meet the criteria for predation. Data on the offenders registered, however, serve only as evidence admissible in court and not for public consumption. However, it is argued that a sex offender registry will do little to address the issue of sexual offences being committed in Malaysia. Firstly, most reports of child sexual abuse in Malaysia drastically outnumbered actual convictions due to the lack of evidence in reported cases and poor investigation, and thus the Attorney General's chambers is often unable to proceed with a case. This renders the register ineffective as there are few or no convictions of sex offenders to go into the list. And secondly, as cited in the case of Munya Anak Calong and Public Prosecutor, where the offender was acquitted following the literal wordings of the Penal Code, where rape is defined only as penetration by the penis and thus excluded fingers. Thus, for as long as the gaping hole in this provision is not revised, more rape cases will continue to go unpunished and render the implication of a sex offenders register useless in protecting children from abuse, as these offenders will evade conviction via exploitation and thus registration. By virtue of the newly amended Child Act 2016, Malaysia now has a child registry, which may be reinforced in its implementation by the Sexual Offences Against Children Bill 2017. But despite this, arguments have been raised that this does not deter pedophiles from reoffending, as studies have shown that most sex offenders, especially those who prey on children, have a tendency to reoffend. Jenny Montana in particular noted in her writings that pedophiles generally have difficulty relating to adults and look to children for companionship and sexual gratification. Thus, by ostracizing child sex offenders, negative social reactions by the adult community may trigger deviant behavior and reinforce the offender's attraction towards children, thus compelling reoffense. Proponents of the sex offender registry say it is needed to help parents protect their children from sexual predators, but there is no evidence that it does that. An analysis and research conducted by Amanda Egan proved that sex offender registries do little to increase public safety. While the threat of being subjected to registration deters some potential first-time sex offenders from committing crime, released offenders appear to become more likely to do so, as they have little else to lose on top of the stigmatization faced upon the dissemination of their personal information and criminal record to members of the public such as prospective employers. Furthermore, it is to be noted that the vast majority of sexual crimes, especially against children, are committed by those close to victims in trusted, often familiar positions, and not by those on the registry. Instead, the presence of the child registry may only heighten community fears concerning the threat of convicted sex offenders and thus arouse community tensions and spark acts of vigilantism. Thus, the benefits of the register will apply only to convicted sex offenders such as Selva Kumar or Richard Harker, who prosecutors believe will pose a high risk of reoffending, which is estimated to make up only 5% of the paedophile population. The Child Registry may therefore ultimately end in counterproductive results in attempting to reduce child sexual offences, more so given the nature of Malaysia's newly implemented Child Sex Register and given Malaysia's laws are outdated, unclear and ambiguous in its wordings.
I think most sexual offenders in Malaysia and the United Kingdom believe that after they commit a crime and pay their debt back to society, their punishment ends. You have a chance to rebuild your life and get a fresh start. The reality is much harsher. We punish people with criminal records long after they have paid their debt back to society, and we all suffer for it. Even simply being accused of a crime, it is the beginning of perpetual punishment. A cycle of legalized discrimination, poverty, and reincarceration. A cycle kept in motion by thousands of laws nationwide and restrict critical rights and opportunities. After contact with the criminal justice system, all these sex offenders are denied employment and housing, denied college education, excluded from receiving public benefit, separated from their children, and deported despite being legal residents and deprived of the right to vote. These restrictions trap the poor and people of colour in invisible cages that extend far beyond prison walls and criminal courts. Cages that lead to a lifetime of obstacles that undermine even the most earnest efforts at rehabilitation and redemption. Cages that send the message, you will never be a part of society again. This is not some isolated problem. A huge number of these sexual offenders return home at some point, and an even larger number are completing non-jail sentences like probation, community service, and or fines. Rehabilitation is sometimes even very difficult due to the fact that the outlook is so bleak. Even for low-level offences and misdemeanors, the aftermath of one's individual experience with the criminal justice system ripples out to entire families and neighbourhoods and gets passed down from generation to generation. The result, more poverty, more crime, and more incarceration. For example, in cases involving consensual sex between parties and thus leading to his conviction, is then denied further education because of the mistakes of his past. I think about how he and so many others are set up to fail, how a conviction on a rap sheet is a snapshot of a moment in time, when all of us are dynamic, changing over time. The criminal justice system disenfranchises these men and women, preventing them from growing, from truly being free. Now, the solution to that is the implementation of the sex registry is ineffective in itself. Thus, the need for the sex offender registry to be scaled down. Firstly, those convicted of minor non-violent offences should not be required to register, nor should juveniles. In the case of violent sex offenders, they should be individually assessed by a psychiatrist, and upon achieving a recidivism rate of less than 40%, should then be registered and be eligible for the rehabilitation program. However, this only applies to first-time offenders, as a second-time convict or a convict who fails this assessment would not be given a second chance and be imprisoned for an indefinite period of time. Such decisions should be regularly reviewed, and offenders who are fully rehabilitated or who grow too old to re-offend should be removed from the registries. The information on sex offenders registries should be held by the police, not published online and released on a sufficient need-to-know basis. Blanket bans of all sex offenders living and working in certain areas should be abolished, as it would make more sense for the most dangerous offenders to continue their full sentence in prison. Prisoner-based cooperatives may have the potential to make a contribution to the rehabilitation and safe reintegration of prisoners in both Malaysia and UK. This includes, firstly, in the context, it is a policy to provide remuneration to inmates to participate in employment programs as part of their correctional plans because it helps them assume responsibility for their expenses and to support their family. And it defeats the idea that convicted felons will be denied employment. Cooperatives involving prisoners give them the capacity to earn money and contribute to the upkeep and obligations. It is understood that they have to work harder than a normal citizen, but this is a result of their actions. Secondly, some forms of cooperative link the production of goods and operation of services by prisoner members with the activities of the cooperative in the community, and thus ensuring a related employment opportunity as the prisoner reintegrates into the community. This is an important component as it provides a seamless transition required for the convicts to reintegrate back into society, as employment is one of the many reasons that perpetuate cycles of crime. Thirdly, this model involves assessment of each convict from their peers as to their commitment and sincerity for entering the intensive program. It is the progress that offenders see in each other and in themselves that sustains the necessary positive environment resulting in change. The chances of recidivism will be reduced significantly as opposed to those who go through a common prison. Now, why these methods to reduce sexual offences? Affording people a real opportunity to re-enter society isn't just good for individuals and families, it's good for all of us. Meaningful re-entry increases productivity, reduces poverty, and saves money. Most importantly, it makes us safer by eliminating the circumstances that perpetuate cycles of crime and punishment. People already get punished harshly by the system, but they should not receive a second system that makes discriminating against them legal for the rest of their lives. By restoring full rights of the citizenship to people, after they have been through the system, we can start to end this cycle of perpetual punishment. We can start to abolish the justice trap. Thus, finding a model that will work in both Malaysia and UK penitentiaries is worth pursuing, as operating and instituting cooperatives in prisons presents a myriad of challenges.